Good afternoon, and welcome to today's webinar titled, What is the ABLE Act? During this session, you will receive an overview of the Achieving a Better Life Experience Act, which is an innovative savings program for individuals with disabilities. You will learn of the benefits and limitations of ABLE Acts, as well as how an ABLE account is a perfect complement to a comprehensive estate plan. This presentation is being hosted by the Family Support Center of New Jersey and presented by Maria Fisher from the law firm of Hinkle, Fingles, and Pryor. While acknowledging the need for education around specific topics, such as today's presentation, the Family Support Center of New Jersey also knows that families have specific questions around their child's transition years. The Transition Matters website assists families and professionals in identifying resources to successfully transition your child or students with special needs to adulthood. Resources such as webinars, in-person workshops, statewide and regional contact information are made available on this site. We encourage you to explore this site further and register for upcoming sessions that you may be interested in. Before we begin, let's take a moment to go over how you can participate during today's web event. Everyone has their own control panel in the upper right corner of the screen that looks similar to the one here. Use the orange arrow to open or hide the control panel. To listen to the webinar, you have two audio options to choose from: mic and speakers, and telephone. If you can't hear well using your computer speakers, you can elect to use your telephone to listen to today's web session. In order to maintain the best sound quality possible, all but the presenters will be muted during today's session. If you have questions or comments, you can submit them using the questions panel. At this time, I would like to welcome Maria Fisher. Maria, welcome to today's session.
Hello. Thank you, Melanie.
So Maria, at this time, you should be able to accept control of the screen.
Oh, I just got the pop-up right now.
Perfect.
Okay, so wait. Where do I click?
So it should say accept or yes.
See where it says accept. It comes up. It says you're the presenter. Go to webinar. You have been made the presenter, and it says when ready, show my screen, but it doesn't say accept.
Okay. Does it say show my screen in the box anywhere?
It does in the box.
Okay. So click on that.
Okay, did that work?
Perfect, we see it. And I apologize for the delay, everyone. We are at capacity for today's webinar, so we are receiving a lot of pop-ups on our screen. So I do apologize for the delay. But Maria, you should be able to now present without any other delays. So welcome.
Perfect. Excellent. So can everybody, you can see my screen now, Melanie?
We can, yes.
Okay, perfect. All right. So as Melanie said, my name is Maria Fisher. I'm an attorney with Hinkle, Fingles, and Pryor, and we'll be discussing the ABLE Act today. I'm sure a lot of you are excited about it because of the potential that it offers us for being able to better prepare for the future of our child with a disability. A lot of you may have done some estate planning and have some special needs trusts. I'm sure there's a lot of questions about how is this different? Why do I care about the ABLE Act, and do I need both of these vehicles? And hopefully all of those questions will be answered by the end of this webinar. So to begin with, we all know that in December 2014, Congress passed the ABLE Act, and the main underlying goal here is parents were saying we need to be able to save for our child with a disability, probably even more so than for our typically developing child. But we all know that we run into this problem that our child with a disability gets means-tested government benefits. And that means that we can't have funds that are in their name, that are in their Social Security number, because it will jeopardize those benefits. And most of us cannot in any way save up the amount of money that our children would actually get through government benefits. So it became this real dilemma. You want to save for your child so that they have security and they have the extras in life, but you can't because it takes away their necessities that they need. Parents have been very vocal about this for years and years and years, and finally Congress responded. And this is the response. The basic concept underlying this is, yes, you'll be able to save for your child that has a disability, but it will not jeopardize those means-tested government benefits. As we go through this, you're going to learn that what I just said, although that's the underlying concept, is not quite the absolute that we ended up with. There are definitely some limitations and some things that families have to be a little careful about when using an ABLE account. So a lot of people, I get a lot of clients who call and say, okay, I want to do it. I don't care. I don't want to know about the limitations. I don't care about the benefits right now. I get the gist, and I just want one of these accounts. You can't do it right now. So we're partway there, but we're not all the way there. So what happened? So Congress passed a law. That's great. The next thing that has to happen is federal regulations have to come out. And those federal regulations are going to tell us all the nitty-gritty about how they're set up, what different benefits there are, how we can maneuver funds into and out of these accounts. That's supposed to be being finished by the federal government. They kind of set a deadline for themselves of the end of this month. Will they make that deadline? That I don't know. Nobody does, but we should all kind of be on the lookout for that. Now, at the same time, each state has to pass a statute, an enabling statute for an ABLE account. I'm proud to say that New Jersey jumped on this immediately, and I don't know exactly where it is, but it was already going through the process right at the beginning of this year. Following that, New Jersey will promulgate regulations that will mirror those of the federal government. Once all of that is done, that's when you're really going to start to see financial institutions saying, okay, we get it now. We know what we can do, and they're going to start being able to sell this product and set these accounts up. So we're just kind of waiting for those pieces. So probably you're a year away from being able to actually open up that account and start that saving. Another thing that's interesting, based on what I just told you, is I'm going to give you a lot of information, but the information I'm giving you is what we know from the statute, from the law. There's going to be more that we're going to learn and we're going to glean from those regulations. So you may ask some questions at the end of this, and I might say, you know what, I don't know. I hope that what you're asking me is able to be done, but we're going to have to wait for those regulations to come out. Just want to kind of give you a heads up. So everything we're learning today is really coming directly from the statute that was passed last December. So these funds in an ABLE account, what can they be used for? Well, they can be used for any qualified expenses for the individual with a disability. And you're going to see I have a list of them up here: housing, education, transportation, health aids, employment supports, therapies. Basically anything that is for the sole benefit of that individual that will help them in their life. There's really not a whole lot of limitation here. The interesting one, and it's one that I put first on the slide, is housing. And the reason that's first on the slide is because some of you may know, especially if your child receives SSI and Medicaid benefits, that funds spent on housing are counted as income to individuals with disabilities and can jeopardize benefits. The fact that funds in an ABLE account can be used for housing and not always jeopardize benefits is what I see as one of the largest pluses and benefits of having an ABLE account. And that's where you're going to see that it kind of differs from trusts that can be set up. So these are the things you can spend those funds on. So the benefits of an ABLE account. The funds that are saved in an ABLE account do not affect Medicaid eligibility at all. Now, there is a lifetime limitation of having approximately $300,000 in an ABLE account, but even if you had $300,000 in there and you're the person who you care about who has a disability that you're setting this account up for has that $300,000 in there, that will not jeopardize their Medicaid eligibility. I wish it could be that clean that I could actually say it won't jeopardize any of your means-tested benefits, but I can't, because the next slide tells us that funds in an ABLE account up to $100,000 will not affect SSI eligibility. So if your child, and I should have said this right up front, I have a daughter who's on the autism spectrum, and she is in her early 20s, so she's receiving SSI and she gets her Medicaid through her SSI. So if I set up an ABLE account for her, I would have to make sure that I only had $100,000 in that account, because if it was $101,000, she would lose her SSI. So you still have to be careful. So it's clear on Medicaid, she'd be able to keep that, but she would lose that SSI benefit. So that does limit the amount that you can put into an ABLE account to being just $100,000 if the individual is on SSI. And when I say SSI, I specifically mean supplemental security income. I am not talking about a benefit that an individual with a disability gets as a disabled adult child on a parent when a parent begins to collect their benefit. That one is different. It doesn't have a requirement for limited resources. So that would not affect it. This is just for individuals who are getting supplemental security income. Has to be below the 100. And to be clear, if you put the 100 in, and this is a vehicle that's earning interest in some way, and that interest puts it over, that counts against you too. So it has to be that it's under that $100,000. The next part goes to the housing thing that I was talking about before. So funds in an ABLE account used for housing do not affect your Medicaid eligibility at all. So you could take $1,000 a month or $2,000 a month out of an ABLE account and pay rent for an individual with a disability, and they would not lose their Medicaid. However, if the individual is on SSI, it is not the same. So for SSI, if you want to remain on SSI, you can't have income of over a certain amount. Right now it's about $764, because the Social Security Administration says that funds given to the individual for housing are counted or quote-unquote deemed to be income. And because the ABLE Act statute doesn't say that we're not going to count it for SSI purposes, that means that if you were to take funds out of an ABLE account for housing that go over that income amount, the individual would jeopardize their SSI eligibility. So we have to be careful. We have to look at the benefits and what the individual that we're setting this up for has. We have to be very careful. If the person's on SSI, there are more limitations with how you can take funds out of an ABLE account. If the person is just on Medicaid, a lot less restrictions. There are some additional limitations for an ABLE account. So the maximum annual deposit into an ABLE account is $14,000. I'm sure some of you are sitting out there and you're noting, oh, okay, that sounds just like the gift tax exclusion amount. And it is. So our thought, although we won't actually know this until regulations come down, is that's probably going to change. Anytime that gift tax exclusion amount changes, that number probably will change. But for right now, the maximum you can put in is $14,000. And that doesn't mean we can open up 3 ABLE accounts and put 14 in each of them. It's for the individual. So it's $14,000 for an individual, regardless of if you have them spread over other accounts. Another major limitation, and this is the one that I think families really need to be aware of, is that funds that are put into an ABLE account that remain in the account at the point when the individual with the disability passes away actually have to be paid back to the government for any government lien outstanding. And it is very likely that if the individual was receiving Medicaid and housing benefits through their state, that there is a lien that is outstanding that would have to be repaid. So if there are funds left over, they're going to the state first to repay for whatever the state had provided. To me, that's a really big limitation, and it's one that families really need to be aware of. Additionally, as we talked about a few minutes ago, in some cases, SSI eligibility will be jeopardized. So families need to be aware of it. It's not a blanket, none of your means-tested benefits can be affected. You have to look at which means-tested benefit the individual is on, and then you have to plan and work with your ABLE account accordingly. So that's going to bring me to the ABLE account versus special needs trust. A lot of you out there may have a third-party special needs trust that's set up with an estate plan. And that third-party special needs trust is the vehicle you are always planning to use, so that when you're not here to provide extras for your child, that there would be this nest egg of savings for them that was going to help them after you're not here to do that. And I have had clients say, well, now that there's ABLE accounts, well, I just don't even think I need a special needs trust anymore. And I would say, I don't really necessarily agree with that. And the reason, there's a couple of reasons for that. First and foremost, funds that go into a special needs trust are not subject to government liens. So if you have a third-party special needs trust that's set up through your estate plan and you fund that, at the end of the life of the individual with a disability, those funds don't go back to the state. They go wherever it is that you have determined you want them to go. So as an example, in my case, funds that are in Tracy's special needs trust after my husband and I pass, and then Tracy passes, we say that goes to our other 2 children. None of it goes back to the government. To me, that's a big plus, because you can feel more comfortable putting more funds into that third-party special needs trust, because at the end of the day, you're time shifting it maybe from your other children, but you're not giving it back to the government. Another important factor is that funds in a third-party special needs trust are never considered a resource for Medicaid or SSI. So where the ABLE account says if you're over $100,000, it's going to affect your SSI, well, that's not the case with a third-party special needs trust. No matter what amount you have in there, it's not going to be counted as a resource. It's just an excluded resource by law, by definition. So that's where that's 2 of the things that where the special needs trust has a benefit that the ABLE account does not. Does the way the funds are used make a difference? And yes, so we already talked about this a little bit. So funds spent from an ABLE account for housing do not affect Medicaid eligibility, but funds spent from that third-party special needs trust for housing, they will affect Medicaid and SSI eligibility. So when it comes to taking money out of either an ABLE account or a third-party special needs trust, they both affect SSI, but the ABLE account has that added benefit where it will not affect Medicaid, and that is important. And here's that ultimate question about, well, can I fund an ABLE account at my death? And my answer is going to be probably not, and that's basically due to that limitation that you can only put $14,000 a year into an ABLE account. So unless at the point where the second parent passes, the amount that you are putting aside to go for your child with a disability is $14,000 or less, then no, you would not, you would not be able to use an ABLE account for that purpose, because it cannot accept the amount of funds that are being put into the account at that point. So for what's the best course of action at this point, I would say, is that the ABLE account is definitely has benefits, and if we're looking at a way to really provide for our child with a disability in the future, the ABLE account should be part of a very comprehensive plan of how to have funds available. I really think the best avenue for families is to actually have both, because then you have the best of both worlds. You can leave more funds, and those funds that are in that ABLE account, those can be used for that housing piece where the other one from the special needs trust wouldn't be able to. So you kind of can cover all your bases by having both of these, but they're not, one is not interchangeable for the other, and both have benefits and both are vital to securing a future for an individual who has a disability. And that slide says what I just said. So, and that was the basic overview and presentation. So now I'm ready and willing to take any questions that anyone may have.
Maria, thank you so much. Can you hear me okay?
Yep, I can hear you.
Oh, perfect. So Maria, will SSA payments be impacted the same way as SSI payments under the ABLE Act?
So I think what the question is going to is that when an individual is receiving an SSA benefit, which is an old age retirement benefit, is what I think they're talking about, based on the parent's work history, would that be affected in the same way by taking funds out of an ABLE account, let's say for housing, or let's just take that piece of it first. Would that be affected? The answer to that is I don't believe so, but that's one of the things that will be fleshed out in the regulations, whether or not that will. I don't think it should, because an old age survivor benefit does not have an income requirement limitation for the individual with a disability in the same way that SSI does. So my gut tells me it probably won't, but I'm going to have to reserve answering the piece on the income based on I don't have the regulations yet. The other part of that question, actually, what they could have been asking is if the person's on an old age survivor benefit, does that $100,000 limitation in an ABLE account still apply? That I would have to say, I would say no. And the reason for that is when you're on an old age survivor benefit, the individual who has the disability is able to save funds. There's no limitation on that. So I can't imagine that it would be any different with the ABLE account. I would think with the ABLE account, it's that would not be a problem. So the short, just to kind of condense that answer, if somebody's on an old age survivor benefit, the amount that's in the ABLE account should not be considered a problem. They should not lose that benefit. I'm just not sure how the income piece of it would be viewed, and the regulations should help us flesh that out.
Perfect. Thanks so much. So our next question is, can you empty an ABLE account prior to a child's death rather than forfeit the capital?
Oh, okay, so if you know if the individual's ill, maybe somebody's thinking, well, we can just empty that account. That's going to be difficult because the funds in there can only be used for the sole benefit of that individual. So depending on how much is in there, yeah, if there's stuff that they need, absolutely, you want to spend that money first, and you do want to empty it. You don't want to have something left there for the government to take. But it's not as simple as saying, oh my gosh, let's go in and take the whole family on a huge vacation and spend it, because that's not, it has to be those allowable expenses, and those allowable expenses are all based on it being for the sole benefit of that individual. So no, you can't just go in and empty it. It would have to be spent on items for that individual's sole benefit.
Great. So our next question is, we have a family who has two NJ Best 529 accounts for their son. One is in a husband's name and the other is in the mother's name. And they are both for the benefit of the son. Can this family roll over both of these into one ABLE 529 account without penalties? And both accounts combined are about $60,000 currently.
Okay. So this is going to be another one of those questions that the regulations are really going to help us. Because I don't know if there are going to be limitations on that. So what I can say is this. First of all, it's a phenomenal question. It's great. And I would say that I would hope that the regulations are going to allow any family that had started out doing a 529 plan and then learned that it just wasn't going to be beneficial to that child, to allow them to roll it over. So couple of things that jump to mind. Even if they let you roll it over, are they going to let you roll it over with $60,000? Or are they going to say it's got to be $14,000 each year? I don't know. Again, that's going to be something that will come out in the regulations. So I'm going to have to kind of say on this one, like, let's wait and see. The concept is great, and I hope that they do allow it, and I hope they do have some mechanism for, maybe since it's already in there, not having it subject to that $14,000 annual limitation. But I really can't say until the regulations are promulgated.
Thank you again. So the next question is, we have a family who has a trust for their son that is funded through a lawsuit. Is this different from a third-party trust?
Yes. A special needs trust that is funded via a lawsuit is funded with what we call funds that belong to the individual themselves. So that's a first-party special needs trust. The trust that I was talking about is a third-party special needs trust, which means the funds that go into it belong to a third party, someone other than the individual with a disability. Major differences between a first-party special needs trust and a third-party special needs trust is the first-party special needs trust, that payback provision that the ABLE account has, that first-party trust has that payback provision. And the reason for that is that the federal government, when they allowed these trusts to be set up, basically said, we could have told you that all those funds that you just received would have to be spent down before we give you any government benefits. But we realize that these funds are there to provide extras above and beyond what it is that the government is able to provide. So we're going to let you time shift. You can put those in a trust and we're going to exclude that. But at the end of the individual's life, everything that we provided for you that should have been paid for by you should end up being covered by what's in that trust. So that's that payback provision. The other major difference is that it has a lot of reporting requirements to Medicaid. They want to keep track of how funds are being spent. They want to make sure that it is for the individual's sole benefit. So there are differences between a first party and a third party special needs trust, and those are the key ones. What I kind of like to just point out is it almost feels like the ABLE Act kind of slips in between these two. So, it's funded with third-party money for the most part. I mean, it's going to be parents, family members who are funding it, but it's got that first-party piece of a payback. So it's kind of in between the two.
Great. So since we're talking about special needs trusts, we have a question of, is a special needs trust and a supplemental trust the same thing?
Yeah. I mean, I obviously I'm not seeing the trust that the person's talking to, but that's kind of interchangeable language. So if it's a special needs trust, obviously it's set up in a way so that it is not going to jeopardize government benefits and allow for the individual to have these funds that they're able to be used for their needs. People use the word supplemental. It's usually very similar because what they're basically saying is this is something to supplement the government benefit. So those words are kind of interchangeable, but the truth of the matter is it lies in the document itself. Without seeing it, I can't say that somebody who has a supplemental trust is a special needs trust, but as a general principle, usually that's what we're talking about.
Great. Maria, are capital gains included in eligibility balance or just contributions? They're asking if capital gains distributed are tax-free.
I honestly do not have an answer for that, but I can get it back to you, Melanie, and then you can get it to the individual.
I absolutely will.
Is this with regard specifically to ABLE account funds, or is this with regard to funding a special needs trust? Do we have a sense of what exactly they're talking about?
So I will ask the person who sent that question in if they will send that comment to us so I can collect that. And I'll definitely get that information to you, and that way I can respond appropriately. As a person with a disability, can someone place their paychecks and stock in an ABLE's account?
So I think the question is, can the individual with the disability fund the ABLE account themselves? I believe the answer is yes. Again, we're going to have to see what the regulations say. And it said paycheck, and what was the other thing it said?
Paycheck and stock.
I would think that the answer to both of those are yes. I think where it might be a no is if we're talking about government Social Security benefits, because those are not really meant to be saved in that fashion. They're meant to be used for basic immediate needs. So that one may be questionable. But again, these are the things that will come out more in the regulations, and we don't have a set answer for that yet.
Perfect. And you mentioned that an ABLE account will be available in about a year. How can someone find out when they are available?
I think there'll be a ton of marketing done on that. I think that the financial institutions will be getting the word out, and that's my best guesstimate that it'll be a year. It could be less, it could be a little bit more. But my guess would be that the financial institutions who will be opening those, which should be similar to those institutions that are doing your 529 plans, that they would be the ones who would be getting the word out there.
Perfect. Does an ABLE account have any effect on a 401k account amounts regarding SSI and Medicaid eligibility? Okay,
I'm not sure if I understand the question. the 401k is not in the ABLE account. So are they asking, does a 401k, having a 401k, does that in any way affect eligibility? If that's the question, the answer is yeah, having a 401k absolutely does affect an individual's eligibility. Except for the Medicaid program workability, a 401k is counted as a resource. And if it had more than $2,000 in it, it would jeopardize SSI eligibility. If it had more than $4,000, it would jeopardize regular Medicaid eligibility. If the person's on one of the waivers, that's a different amount. The only one that would exclude a 401k that's funded with the individual's own money is workability. But I'm not sure in the question where the connection between that and the ABLE Act, unless they're asking can they transfer a 401k into an ABLE account, but that didn't really sound like the question. The answer on that would be obviously if it's under the $14,000 they could. Probably we'd have to see what the regulations say as far as if they're going to allow people to do that, and again, the regulations aren't out yet.
Great. So if that person's question was non-answered, I will just ask you to please elaborate a little bit on your question and resend it if you would. We do have a few more questions that I want to give Maria, if that's okay. Mm-hmm. Is an ABLE Act or ABLE account applicable? Thank you. To all special needs populations. Also, would it pertain to a child and an adult alike?
Yes, it pertains to child and adults alike, and the person does have to have a qualified disability. Similar to being able to be eligible for SSI or Medicaid. So that they do have to have a qualified disability.
Perfect. And who is required, or who would you suggest be the account holder for an ABLE account and trustee for special needs trust? If more than $14,000 is put into the account, is a gift tax form and payment required?
Okay. That's a whole lot of questions. So
yes.
The trustee question on a special needs trust, the answer on that really depends on the individual family situation. So typically if it's a third-party trust and we're funding at the death of the parents, we're looking for it to be somebody else. Families normally look to, when the parents are younger, they look to their own siblings to take over that role in case the parents die early. When the parents are much older, they usually look to their typically developing children to take on that role. Depending on how much funding there is, you could have a corporate trustee, which is a bank or financial institution. If there's no family member to serve, you can look to a nonprofit like a Plan New Jersey or some of the ARCs provide those types of services in case there's no family member who's able to step in and do that. But you're looking for someone who understands your child's needs, understands how those funds can be used, understands the benefits that an individual with disabilities is receiving so that they don't jeopardize them. And you're looking for someone obviously that you can trust long term because they're going to be handling the funds that you've put aside for the individual. To the ABLE account. This is interesting because there's some debate over the fact that it looks as though, and again we're going to wait for this to be fleshed out because there's been a lot of pushback on this, that the individual themselves is going, it's an option for them to be the ones who are able to really deal with the funds in the account. And a lot of families are saying, gee, that just doesn't work. But again, if it's a family member, we're going to look to the same kind of criteria that we're looking for with the special needs trust. However, with the special needs trust, it could never be the individual with a disability. They cannot, because that gives them incidence of control and ownership over the funds, and that would make it a countable resource. It's a little bit out there on the ABLE account, and there's been a lot of talk around it, so that's something that we may see fleshed out in regulations and we may see change. And I think there was a third question, which I've now forgotten.
I think you actually addressed the whole question.
I did? Okay.
I believe so. So we have a few more that we're going to move on to. Will an ABLE account affect eligibility for any other government benefit such as SNAP?
That's unclear. The ones that I mentioned are specifically mentioned in the statute. Whether or not it's going to affect other benefits or allow other benefits to see this as an excluded resource, We don't know. That's going to be in the regulations.
And can you just, again, offer some clarity? Is the $14,000 per year amount limited to the total deposit into the account or just from each individual donor, such as
Total.
14,000? Okay, perfect.
Yeah, it's the total amount. It's the annual limit going into that account from whoever. So you have 14 people, they can only put 1,000 each.
Okay. And if someone has, if parents have a 401k with over $2,000 in it, does that mean that this person's son would not be eligible for SSI and therefore eligible, and therefore an ABLE account?
Okay, hold on. Just let me go back to the other question because I may have answered it incorrectly. When we talked about the 401k before, I thought the person was asking about a 401k that belonged to the individual with a disability. So in this question, we're saying it's the parent's 401k has more than $2,000 in it. As long as the individual with a disability is over the age of 18, the parent's income and resources fall away and are not counted against them as far as eligibility for Medicaid or SSI. Before the individual reaches the age of 18, that would be counted and it would be counted against them. It would jeopardize their eligibility. So just to be clear, if the 401k belongs to the parents and the individual is over the age of 18, that's not a problem. It's if it's a 401k belong to the individual themselves. And what was there was another piece about whether they would be eligible for an ABLE account because the parent has a 401k. There's no connection with that.
Okay. And is there any reason why someone shouldn't access SSI? Are there any negative ramifications that you can think of that would occur later in life?
Is the question, should people put off going for SSI eligibility when the child's 18?
So I will ask that person to please resubmit your question with extra clarity. But if you want to answer the question going in that route, that would be great.
Yeah. So all right. So let's start with this. If the question is, should we wait and not have and not get SSI eligibility for a child right away at 18? I would say absolutely not. You want to do it right away at age 18. There are a number of reasons for it. So first of all, it gives the individual with a disability a monthly amount of money coming in. That amount of money is somewhere between $500 and $700 a month to be used for their sole benefit on their basic needs, food, clothing, and shelter first, but then it can be used for anything else that's for the individual's sole benefit, so co-pays on medicines, therapies, educational expenses, any of those kinds of things. The additional benefit is in the state of New Jersey. If you're eligible for SSI, you're automatically eligible for Medicaid. You do not have to fill out a separate application. So if you do this at age 18, your child now has SSI and Medicaid, and as many of us know, if you're looking to the Division of Developmental Disabilities to provide services for your child after the age of 21 when they are terminating the educational entitlement terminates, the division requires you to have Medicaid in order to get services. So it makes complete sense. Do it at 18, have it in place, have your Medicaid. This way, when you get to 21, you're just worried about transitioning out of school, finding the right program, working with the division to have all of that set up. You're not in a situation where it's like, oh my goodness, I don't have my Medicaid in place and I have to scramble and do something else. Additionally, an individual with a disability who has been disabled before the age of 22 who receives SSI, at a point where a parent passes and that individual is then entitled to a higher benefit based on the parent's work history, and in many cases, the higher benefit that they receive actually knocks them out of eligibility for Medicaid and SSI because of the fact that it's a higher amount and it's counted as income. If that individual is receiving SSI first and lost their SSI only because they're getting that higher benefit on the parent, they are able to keep their Medicaid in place due to a federal regulation, and that is vital. Because otherwise some of these individuals find themselves in a position where they cannot, if they've never received SSI and they started out and they started getting an old age survivor benefit on a parent's work history that is in excess of the income limitations, they can find themselves in a position where they cannot get Medicaid which would translate into a difficulty with the division. Although the division counts these people as an exception and is working to try to find a fix for it, there's just no reason to put yourself in that position. Get the SSI as soon as you can so that if anything were to happen and the child is then getting that higher benefit, they have the benefit of this regulation that was put into place that allows them to keep their Medicaid.
Maria, I'm going to give one last question if I could.
Yeah, absolutely.
We had a lot of discussion today on an ABLE account being funded, and if someone passes, that money gets forfeited. Would the property purchased through the ABLE account after someone passes also be forfeited, or would that be left to the family?
Okay, so let's start with this. I don't want to make it sound like it's a blanket forfeit of everything in there. It's paying back the government for the lien, but up to the amount of the lien. So if you have, the max you can have in an ABLE account is $300,000, and if the individual passes and you have $300,000, but your lien to the government is $100,000, they get the $100,000, you get the balance back. If the person's question regarding property purchased means that they purchased a home with the funds, we're going to have to look at the regulations when they come out to see how they would look at that. My gut would say no, but that would not be the case because it's not as if it requires that home to be held in the name of the ABLE account. So it would seem to me that the funds are spent and they're outside of the ABLE account now, and they would not be subject to that lien. And as far as other property, I'm not sure, other than a place to live, I'm not sure what they would be looking to, because those funds are being used for those qualified expenses, therapies, doctors, educational, job assistance, those types of things. Most of them don't have something tangible attached to them that would still be property that the family would have at the end. So the only thing I can think of is a house. And I don't believe, although we would have to wait to see what the regulation says, that if money used from an ABLE account is used to purchase a house, that the title of the home has to then be within the ABLE account. That's going to be the crucial telling factor depending on what the regulation says.
Maria, as always, it's a pleasure working with you, and we thank you for sharing this valuable information with everyone who attended today. On behalf of the Family Support Center of New Jersey and the law firm of Hinkle, Fingles, and Pryor, along with Maria Fisher, we thank you for joining us today. Please know that this session will be archived and accessible through the Family Support Center of New Jersey website, which is fscnj.org, and that will be available over the next week for your convenience. Maria, we're hopeful that we'll be able to provide an update to the ABLE Act as soon as they are announced. And if you would be so gracious as doing it a part 2, that would be wonderful. And to everyone in attendance, if that is offered, please look for emails in the future to allow to let you know of this opportunity.
Absolutely. I would be thrilled to do that, Melanie, and thank you again. Family Support is such a great resource for all of our families, and we really appreciate being able to work with you and share this information with everyone.
Well, Maria, thanks as always. We'll talk to everyone soon, and thank you for joining us. Enjoy the rest of your lunch hour.